Hi, everyone. Harry here to talk about Trump's demand for $230 million of federal taxpayer money as compensation for the supposedly improper criminal process that he was subjected to, the Jack Smith prosecutions, and he also says that the search of Mar-a-Lago in the second case was improper, violated his rights, and he has initiated a process that exists but almost never results in any kind of payout for defendants. The process is flawed in all kinds of ways, but let me just start with the substance. This is part and parcel of the overall attack, Orwellian attack, because it's such a fiction, on the bona fides of the claims and prosecutions against him. It's really, and as an ex-DOJer in particular, I find it really despicable. Give me a break. Of course, there was a solid case and predication to draw up a criminal, to investigate and draw up a criminal complaint for everything he did in the January 6th case. Ditto also Mar-a-Lago. These are both completely righteous cases. And the search claim on Mar-a-Lago, if I understand it correctly, this is the one he's always been propounding, is also a joke. What he's saying is they waited till he was gone to do the search and that they should have alerted him. You don't alert defendants that you're about to search their place, and they therefore violated his rights of privacy. Okay, so that's for starters, in any world of fair, objective evaluation of facts, the basic premise that there was anything improper here is not only wrong, but is, in Trump's Orwellian way, ass backwards. It was a completely righteous prosecution, a completely solid search. So that's just for starters. All right, now this claim. So, and the kind of impossible ethical imbroglio that it gives rise to. The way this normally works is you file an administrative claim first, a piece of paper with the Department of Justice saying, I think you owe me money because this was spurious. At that point, the DOJ, it's at least ripe for negotiation. Almost always, I can't think of a time since there used to be a different legal regime that made it somewhat plausible, gave, a narrow opening. Now it's just the Federal Tort Claims Act. And as I'm going to explain, there's, several reasons why it's almost impossible, even in the most egregious of circumstances. And of course, these are the most righteous of circumstances. But he filed 2 years ago, it turns out, this, 2-page piece of paper like you might apply for a driver's license. It really doesn't say much, but makes this assertion. Oh, and then the $230 million, classic Trump. What's that got to do with anything? It's, remember he just sued the New York Times in defamation for, let's call it $150 billion. It's just untethered from anything real. But the big thing is, who's going to decide this claim? Typically, it would be the Department of Justice and maybe the Deputy Attorney General, Todd Blanche. Todd Blanche, in this case, not only was involved as his defense attorney in all the conduct that gives rise to the claim, so he's flagrantly disqualified from having anything to do with it now, but even more, he continues to say, implausibly, illegally, head-scratchingly, that he remains, even as he is the Deputy Attorney General, Donald Trump's personal lawyer. It's a violation of his constitutional oath. He works for the people. He takes care that the laws be faithfully executed to the extent, and it's happening, week in, week out. There's any conflict between that and Donald Trump's personal interest, he must, by dint of his oath and, everything that the DOJ stands for, not represent Trump personally, but he does it anyway. In the shadow of this is in Trump 1.0, when John Ashcroft did recuse himself from the Russia inquiry. Of course, he was absolutely duty bound to do it. Trump went berserk, still goes berserk, and so he's going to try to insist and ram it through by sheer executive authority that people who clearly have no business participating, indeed, if they do, their license could be in jeopardy. Nevertheless, he's going to say, Todd Blanche, I want you to make the determination based on my little scrawled note to give me $230 million. So that would be ethical disaster. And I think a lot of people, including some Republican senators, saying it would also be a political disaster. Right? It's $250 million. The government is closed down. People aren't getting health care and the like. And they write a check of taxpayer money for $230 million to Trump. Then there's a whole nother dimension here of what would come next, because where he now would be is the way it works is the Federal Tort Claims Act is now the legal regime that governs whether or not the U.S. Will pay out the money. And here, all the times that we've seen Trump avail himself of doctrines that say if you are acting in your official capacity, you are not subject to any kind of liability. Remember with E. Jean Carroll, he said, when on the lawn of the White House, he said, she's not my type. I don't know who she is. And she said that was defamatory. His first claim was, that was me in my official role, and which seemed kind of dubious. It's what the courts had to handle. Well, here, it's not simply that the claims are righteous, but Jack Smith, anyone the FBI who did the search in Mar-a-Lago, anyone whom he would allege did something wrong are plainly acting in their official capacities. And that means in and of itself, there shouldn't be the U.S. Remember, the Federal Tort Claims Act gives liability against the United States only where the United States as sovereign has waived it. So, for example, no intentional torts. That's why if the defamation argument he had made succeeded, the whole case would have gone away. Defamation's an intentional tort. If he was in his official capacity, it would be the U.S. That the suit would be against, and the U.S. doesn't permit that. We have similar kinds of traps here involving any kind of allegations of official conduct. And then beyond that, immunity generally for executive branch officials, but even higher, a really high level of immunity for prosecutorial decisions. So, essentially he would need to show like an intentional, nasty plan to get at him personally, knowing that the law wasn't there, something along those lines, if it came into Federal Tort Claims Act land, which it never would anyway, because another requirement is that everything has been completed. And in fact, they've been dismissed, but the case, this is only supposed to be a remedy. Once you go to conclusion, a jury rules for you, and it goes all the way up, and we have some determination in the courts that this was, as you're alleging, a really meritless prosecution. We don't have that here, and that's essential under the Federal Tort Claims Act. So the whole thing is just, a complete phony kind of move. He's got, no right to it. He wouldn't have a right to it if he had a right to it, because it's so plainly wrong on the merits. And the whole notion, but he could actually try to force this through And it certainly would be, a political scandal. But the whole notion that somehow the person who represented him in these very criminal investigations and is still there, you can't imagine a more stark conflict of interest, a more stark constitutional violation on the part of more stark ethical violation on the part of Todd Blanche, and also a constitutional violation in the sense that he is sworn to take care of the laws, be faithfully executed, and he would be writing a check for $230 million, say, from the people's money from the fisc to give over to his boss and client. It's completely head spinning in every different way. And then finally, you can't just say $230 million, even though Trump is wont to say it. You'd have to, we need chapter and verse of why, what's the money. And in fact, when these are paid out, there's a practice, a rule in the Department of Justice, though all rules have been raised in the Trump era, but that says if it's more than $4 million, a payout here, it has to go all the way to the top to be approved. That gives you an indication of the neighborhood of these claims normally, under $4 million. And here, of course, as with all things Trumpian, that's just exploded to smithereens. And he says $230 million. But again, under the law, if it did apply to him, we'd have to have some very punctilious proof of the same. So politically, it's a mess. I'll set that to the side for now, but you have even some Republicans saying, "Geez, don't do this, Mr. President." Ethically, it's a huge mess, and legally, it's a non-starter, both because the prosecutions were solid and righteous, but also the many procedural impediments, some of which in the past he's tried to take advantage of under the Federal Tort Claims Act. So this 100% should go exactly nowhere, except for the fact that is happening in other instances. You have a corrupt Department of Justice now letting itself, going supine and letting Trump do whatever he wants. And maybe even a Supreme Court to say, well, that's the unitary executive. Sure, it's unethical, but if he says we don't have to comply with ethical rules, well, that's his constitutional prerogative. Shows how very, very far upriver we are in only 10 months of the Trump 2.0 administration. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.